Okay, good afternoon again to everybody on the call today. I want to welcome you. This presentation is being recorded and the slides will be available to you sometime down the road. Um, Appreciate you joining us for Ask the Expert. I'm Steve Schillig, the moderator, the director of the Small Business Development Center. We're headquartered at Kent State University, Tuscarawas. For those that are not aware, the Small Business Development Center provides confidential, no-charge consulting. We have a team of specialized counselors with backgrounds in marketing, food service, leadership, finance and accounting, computer technology, and I'm so glad to admit that we now have an expert in patents, copyrights, and trademarks. And that's why you're here today to listen to Jake. So those resources are available to you on a confidential, no cost basis. We have muted everybody for our speakers' benefit. If you have questions, please use the chat room. You can find it in the ribbon below your screen or up in the upper right-hand corner. If you hover your mouse over it, it will read show conversation. And in past presentations, Jake has been very open and welcoming any kind of questions. So take advantage of that if you do have questions. We wanted to offer this workshop to provide some really good information on intellectual property law for businesses and entrepreneurs. We find this information very valuable. I'd like to introduce to you today Jake Ward. He's a registered patent attorney, admitted to practice before the United States Patent and Trademark Office in the state of Michigan and before the United States District Court of Eastern District of Michigan. Mr. Ward is also a registered Canadian patent agent, non-resident, admitted to practice before the Canadian IP office. I'll have to hear more about that. I've read it before, but I didn't really pay much attention, so that's interesting. Mr. Ward is the founding partner with the law firm of Ward Law Office in Tiffin. His practice consists of preparation and prosecution of patent applications in various technical arts, including the chemical, mechanical, and electrical arts. Mr. Ward also prepares legal opinions in relations to patentability, infringement, patent validity, and freedom to practice. He received his Bachelor of Science degree in biochemistry from the University of Dayton and his Juris Doctor degree cum laude from the University of Toledo College of Law. At the University of Toledo, Mr. Ward was also awarded the Certificate of Concentration in IP. He was also materials chemist for several years with the Cooper's Tire and Rubber Company in Findlay. He told me before we got on the call that he is an adjunct professor at the University of Toledo, so he certainly enjoys presenting and providing information, and we're so glad to have him today. So at this point, I'd like to turn it over to Jake.
All right, Steve. Thank you for the introduction, and again, I want to thank the SBDC for hosting these webinars. This is actually the third in a series of intellectual property webinars that we've given. So the first two being patents and trademarks. And the topic here today is that we're going to talk about is copyrights. So it'll be a little bit of information, some basics about copyrights, how to recognize them in your company. As Steve and I were sort of joking about a little bit before everyone jumped on. One of my sayings, and he remembered it, was, every business has IP in one form or another, and whether you recognize it or not. And so these webinars are all about trying to recognize your intellectual property, know what it is that you have and that you own, and then you can make the educated decision whether you want to leverage that in any way, shape, or form. With that being said, hopefully everyone can see the screen here. The slides should be up on the screen. And as Steve had mentioned, if you do have questions, do sort of type them into the dialog box, on Microsoft Teams here, and we will try to get to those here at the end of the webinar. So with that said, let's see here. There we go. So slide number one, and this is where I start all of my intellectual property webinars, really, is to ask the question first, well, what is intellectual property? I mean, we hear that term thrown about sometimes, and maybe you don't understand quite what that means. So IP, the abbreviation for intellectual property, There is a legal definition there, which I don't even bother to read. That comes from Black's Legal Dictionary, probably a decade plus ago when I first pulled it. Like I said, I want these webinars to be practical for startups and entrepreneurs. And so even though there's a legal definition there, I think it's best to try to frame intellectual property and understand it in terms of the actual types. And there's 4 basic types of intellectual property that we generally are concerned with. And those can be sort of split off into 2 buckets or groups. We have the not patents and the patents. So like I said, a couple weeks back, we talked about patents. We've also talked about trademarks. We haven't had a webinar on trade secrets, but we can look at perhaps doing that. But the 4th type of intellectual property there on that list is copyrights. And that's what we're going to be talking about here today. So that's what we mean by intellectual property. It's one of those 4 types of IP. So now that we know generally what intellectual property is, why we're here to talk today, this slide here is all about why do we care. And I thought this is a really interesting number. I know this is an old number now. This actually came from an economist's report that I had seen many years ago, but it illustrates the point. And again, why do we care about intellectual property? Well, IP is a type or a form of property. It has all the attributes of personal property, and being a type or form of property, it has an inherent value associated with it. And from this report, you can see here, some economists have estimated that if you were to sum up the value of all the intellectual property domestically, it would be worth more than $7 trillion. So a lot of zeros there. Like I said, that number may no longer be accurate, but it serves its purpose. Why do we care? It's because IP has this inherent value. The Coca-Cola company, and in fact, I do have here my handy dandy IP demonstration tool. If I was giving this in person, I would always pull this out at this point of the seminar. But the Coca-Cola company, I think, is a really good example of intellectual property and its value. It's been estimated that if you were to take that company and strip away everything physical from it, so we're removing all of their inventory, getting rid of all their buildings and their real estate, getting rid of all their machines and equipment, strip it down to nothing but the IP assets, that company is still worth more than $70 billion. And again, where is that found? It's going to be in the trademarks. It's going to be in the trade secrets. It's going to be in the patents and the copyrights that they have. $70 billion. So underlines the importance. Why do we care? Why do we talk about IP? It's because of this value. Okay, so for today, we're not going to be talking about patents or trademarks. Feel free, if you do have questions, you can put them in the chat, the chat, or reach out to me later, and I'd be happy to talk with anybody about patents and trademarks and trade secrets. But as of today, we're going to be talking about copyrights. So copyright basics, rule of thumb. The thing that I want you to remember, if you don't take anything else from this webinar, what is a copyright? All right, here's the answer. A copyright protects the works of authors. Works of authors. Okay, that's what we are talking about when we're talking about copyright. What sort of works are we referring to? Well, copyright generally is used to protect things like writings, books, articles that you may have written, music, all right, other classical examples of subject matter that can be copyrighted. But it's more than just that. It's anything that has at least a little bit of creativity associated with it can be covered by copyright. So other examples would be paintings, photographs, code, software code, the actual written software code. All of that is considered a work that can be covered by copyright because there's that modicum, that at least tiny bit of creativity associated with it. What do you get with your copyright? Well, you receive what is called a bundle of rights. The copyrighted lawyers will call it. Most notably, It is the right to prevent others from copying or reproducing your work without your permission. That is the copyright at its most basic. But it's more than just that. More than just the right to prevent people from reproducing your works. It allows you, if you're the copyright owner, to prevent others from distributing the work, selling it without your permission. It also allows you to control performances or displays of the work. Now, this is especially important when it comes to things like television broadcasts or musicals and plays. The right to perform or display the work is a right you have as one of the bundle of rights. It also importantly gives you the right to prevent people from making derivatives of your work. And what do I mean by a derivative? Well, if this were normal times and we were giving this as a normal seminar actually on site, I would sometimes use the example, that perhaps when I drove in today, I would get out of my vehicle in the parking lot and I would see the building that we're in. And, I'd say, well, the sun is shining just right. That's actually a really nice photograph, really nice picture. And I would take my camera out and I would snap a photograph of the building. At that point, I'm the one who selects the angle. I'm the one who selects the lighting, the conditions. I am actually the author of that work. And let's say I go and I, post that on my social media, this color photograph. And let's say someone else sees it the next day and they say, oh, that's really nice, but I think that photograph would look even better as a black and white print. They take my photograph and they convert it to grayscale black and white. All right. And let's say they start distributing it or selling it. Have they made an identical reproduction of my work? No. But have they made a derivative of my work? Absolutely. And as the copyright owner, as the author, I have as my bundle of rights the right to prevent people from doing that without my permission. Okay, so that's what we mean by controlling of derivative works. A couple other things to look at here. This is also, if we were testing here at the end of the day, what I might accept as a rule of thumb would be that not only does copyright protect the works of authors, but it also can be seen as protecting the expression of the idea and not the idea itself. That's important. It's the expression of an idea. Copyright doesn't protect the basic concepts or ideas or facts that underlie it. Facts are freely available for anybody to use. But my example here, maybe let's say I'm an author and I decide one day, I have this idea in my mind, and it's this idea about a story I'm going to write, and it's going to be a story about boy wizards. And maybe these wizards, they go to a school for wizards. Maybe they get into all sorts of mischief, right? Go on adventures. The question would be, does J.K. Rowling, the author of the Harry Potter series, have the right to prevent me from writing my story about boy wizards? And the answer is no. And it's because of this fact here, because copyright protects the expression of the idea, but not the idea itself. J.K. Rowling, as talented as she is, does not own the idea of boy wizards. She owns the particular expression of that idea in the Harry Potter series. And so I would not be able to perhaps use the same storylines as her, probably, maybe even characters and certain character development. I certainly wouldn't be able to make a close copy or paraphrase of her works and pass it off as my own. That's the she has, but she cannot, under copyright law, make any claim to the basic idea itself. So that's important to know with copyright. It's expression of an idea that is covered. A couple other interesting factoids here about copyright. We like to say that the copyright exists immediately, and here's a little bit of legalese for you. It exists immediately upon creation of the work and fixation in a tangible form. What do we mean when we're talking about fixation in a tangible form? We are generally referring to the making real of this in some way, shape, or fashion. Going back to my example about my book I'm going to write about boy wizards. While it's in my mind, do I have a copyright? Well, the answer is no. But immediately upon taking pen to paper and writing down the story, it's now physical. It's been actualized. Does a copyright exist at that point? And the answer is yes, because the expression, the work, its creation has now been fixed in that tangible form. Same thing applies to typing it up on a computer. It is now fixed to the hard drive, either on my computer or to a computer up on the cloud someplace. It's been made real. And so you have that copyright immediately as the author upon the creation and fixation in tangible form. Because of that, and because the copyright exists under law immediately, you don't actually have to register your copyright in order to claim it or to use that Circle R, the Circle C symbol, which we see here. The copyright symbol, Circle C, we recommend if you have work that you're working on that you place the symbol on there. Generally, you'll see the format being Circle C followed by the name of the author or the company that owns it, followed by the year or date. Sometimes you'll see on the copyright notice the words "all rights reserved," but that's voluntary. All rights are reserved by law unless you say otherwise. So it's almost stylistic whether to include it or not. The important point behind marking your works, though, with the copyright notice is that you're placing the world on notice that you are claiming this as being yours. You're fencing it off. And if they copy, they do so at their own risk. And so, again, two important points there. The copyright exists immediately upon creation and fixation in a tangible form or medium. And you have the right as the author to begin using the copyright notice immediately. And it's generally recommended that you do. Okay, this is a very common question. This next slide, how long does my copyright last? I'm here to tell you that that copyright law has changed significantly over the past century or so. You go back in time to 100 plus years ago, and copyright was good for a period of 14 years, period. You would create your work, and immediately upon creation, you had 14 years to enjoy that limited sort of monopoly that comes with the copyright. Thanks to some lobbying and the good work of certain congressmen and companies. You see Mickey Mouse up here. The Disney Corporation has certainly had a part to play in the expansion of copyright over the past century. Copyright owners now enjoy a very long-lasting and strong right. How long is a copyright good for? Generally, in the case of individual authors, it's going to be the life of that author plus 70 years. And when you think about that, that's a really long time. I sometimes will say that copyright is finite, but in no meaningful way. Well, that's exactly why. I mean, if you're the author and you have the right for your entire life, plus 70 years. That means that right is going to exist probably for your children's lifetime, maybe even your grandchildren's lifetime. So it's a very long-lasting, very strong right. And even though finite, it's not finite in any meaningful way. In the case of corporate works, so corporate authorship, the rule is slightly different, but still very long-lasting, very strong right. 120 years after creation or 95 years after publication, whichever is earlier. The real sort of answer to your question, if you're trying to wonder, well, how long is this copyright I'm looking at good for, is you may want to, speak with a copyright attorney, and they might be able to give you an answer. But it's not usually a simple answer or a simple question to ask. Now, this next part of this slide, I think, is probably one of the most important take homes you can take out of this copyright webinar. Remember I said a few moments ago that you have the copyright immediately upon creation and fixation in tangible medium, and you have the right to use the copyright notice. All of that is true. So registration at the U.S. Copyright Office, which is the federal agency in control of copyrights, is not mandatory. Like I said, you get to use the Circle C regardless of registration or not. But it is encouraged, especially if this work that you're dealing with is something valuable to you or to your company. Why is registration at the U.S. Copyright Office encouraged? Well, generally, you won't be able to bring a legal action for infringement unless you have actually registered your work. That's actually, you would think that that would have been something that would have been known for many, many years. We actually just had recently at the U.S. Supreme Court a decision relating to this, and they confirmed that, yes, you do need to have the registration act for infringement. Another sort of interesting facet to copyright law relates to damages that you can potentially claim. In most other areas of the law, if you're going before the judge and you're claiming you've been harmed in some way, and you're asking for monetary compensation, you're not looking for a lottery win. You're looking to be made whole. That is the purpose of the law, generally, is to make you whole based on some damage or wrong that's been done to you. It's what we call actual damages. And again, depending on the situation, actual damages can be converted into some sort of monetary sum. You do have actual damages available to you as a copyright owner under U.S. copyright law, but you also have what are called statutory damages. I sometimes refer to this as the big hammer of copyright law, and for a reason I'll get to here in a second. What this law says, if you make your registration within 3 months after publication or prior to someone infringing, you can claim statutory damages and attorney's fees, regardless of whether or not you've been actually damaged or not. And what we say the statutory damages are, it's $750 per work, up to $30,000 per work infringed. All right. If you're found to have been willful in your infringement, you are looking at potentially treble damages, 3 times this amount. This is why I refer to it as the big hammer. And I've had clients who have been on both sides of this situation. And I'm telling you, if you're the copyright owner, you want to be able to threaten, an infringer with statutory damages. It's going to cause them some sleepless nights. It's going to make them get to that settlement more quickly and in a position that's more amenable to you. You definitely don't want to be on the other side of this. It is a situation where it's a great tool to have as the copyright owner to be able to claim statutory damages. Otherwise, as said here, if you don't register, you may be limited to any actual damages too, in an infringement action. All right. So we just talked about how you can use the copyright notice without registering, but however, registration is generally encouraged. You might be asking the question next, well, how do I register? Of all the forms of intellectual property, the copyright registration process is probably the most straightforward. I encourage anyone who is interested in this, check out the Copyright Office website first, copyright.gov. So that'd be www.copyright.gov. You can file your own copyright registration applications online, using their forms. There are also forms that can be obtained from the U.S. Copyright Office, here at the place located on the screen. The cost for a copyright registration application is fairly low. Especially given the context of trademarks and patents, where, a trademark registration application at a minimum is $225. Most in government fees. A patent application, you could be looking, depending on your entity's type, entity type, several hundred to thousands of dollars for patent applications. For a U.S. copyright application, it's $65 or $45, depending on whether or not it's an individual work or a corporate work in terms of government fees. So again, very inexpensive. It's another actually reason, if you are dealing with some form of work, creative work that has value to you and your company, another good reason to seek the copyright registration, other than what all the legal reasons I gave you, is it's fairly inexpensive. The registration is for formalities only. So again, this is different from trademarks and patents, where there's a substantive examination that occurs. When you file your copyright registration application, the copyright examiner assigned to your case is going to basically look at, did you fill out the form correctly? Did you provide your deposits, that show, or which are examples or samples of the work, and did you pay the fee? Assuming you do all of this, then it's fairly mechanical. And about 6 to 9 months after you file the paperwork, you would expect to receive the copyright registration certificate in the mail. So like I said, it's easy, relatively inexpensive. Obviously, if you have difficulty with it, you can always go to a professional and talk to an attorney. We're always happy to help people with copyright applications too. But I'd say as a first step, check out copyright.gov. Take a look at their forms and their explanations, which of all the types of intellectual property offices, I think are pretty good. All right, this slide here is about copyright ownership. As mentioned at the top of the slide, it could be a complicated question, but general rule, and this is something to keep in mind if you are a startup or a business owner, the author is usually going to be considered the owner of the copyright. Okay, that is sort of the default rule. We do have one exception to that, known as the work for hire exception. The work for hire exception basically says that in certain cases, an author's employer is going to be considered the owner of that work. This is done where the author in that case is a statutory employee, and it falls within the scope of their duties or their job description to make creative works. In which case, the employer will be considered owner by work for hire. Another exception to this general rule that the author is the owner is where there's a written agreement otherwise. And this is very important. In fact, I put on here on the screen here, it's a very common mistake where a lot of times startups, individuals, they will contract work out. You don't have a ton of statutory employees necessarily when you're a startup. So you're going to be contracting things out, maybe software development, maybe websites, or perhaps other sorts of creative works, people making creative content for you. These parties that you're dealing with are what we call third-party contractors. All right, and it's counterintuitive. It doesn't make a whole lot of sense, but I'm here to sort of give you a warning and be aware of this. If you're a startup or a business and you're working with third-party contractors to create works for you, it's important, extremely important, that you have a third-party contractor agreement in place. And from an intellectual property standpoint, there's some magic language that we look for in these agreements. And what we want to see is what's called an assignment or an obligation for assignment, whereby this third-party contractor is agreeing that any creative works they make for you, that the copyright will be transferred to you. Because remember, if they're not a statutory employee, most likely that it won't be considered a work for hire exception. And even though you're paying them money, let's say to make the website, to make the software code for you, you don't necessarily own the copyright underneath the law. So like I said, I always mention it here. It's a common mistake. It's counterintuitive. So, rule to sort of remember when it comes to the ownership, if you are dealing with a third-party contractor, it must be in writing. And by law, it must be in writing in order for that assignment to be effective. Only other item here we have on the screen is what we call the fair use exception to copyright infringement. Also very complicated. In fact, we could probably talk for a full seminar, another hour or two, on fair use. What fair use means is that in certain very limited circumstances, it's okay to use somebody else's work without their permission. There's a list of factors that are considered in trying to determine whether or not a use is going to be a fair use. What we look at is the purpose and character of the use. Was it commercial versus non-commercial? You look at the nature of the work that's being copied. How creative is it versus how factual? Because remember, facts themselves not copyrightable. It's just the expression of them that really is. You can sometimes look at how much or what portion of the work was creative. or excuse me, was borrowed or was used without permission. But there's no set rule. Sometimes, I've had artists who have come to me and said, Jake, I've heard this. It's like a 7% rule or 10% or 15%. That I've heard that, yeah, as long as I don't use more than 15% of that work, I'm okay. Well, not necessarily. The amount and substantiality of the portion that you're taking comes into play, but there's some good case law that says even if it's a tiny percentage of the actual work that you're taking, it can still be considered an infringement and not fair use. The one example that sort of comes to mind, and this was many years ago at this point, there was an author who had written a biography on a presidential figure, and the presidential figure, there was a particular page within this text, and we'll just make it up. We'll say it was a 700-page tome, 700-page book, and let's say there was one page in there that talked about a particular relationship that this president had, an extramarital relationship, I guess you could say. And a newspaper had picked up this book and was doing a review on it, and they reproduced that page, and they were sued for copyright infringement. The newspaper would argue at court, well, listen, it was fair use. We were doing a review. Commentary and criticism is actually another very common way of using or fair use or applying the fair use exception. And we only took one page out of 700. So what's the big deal? Well, the court came back and said, you know what, it is a big deal because that one page of that book was the reason people were buying the book. It may have been 1 out of 700 pages, but it was the most important page commercially, in that entire text. And so that even though it was just one page out of 700, that was deemed to be not fair use in that case. So a bit of a war story there, just an example. When it comes to fair use, like I said, commentary and criticism, educational uses are generally, likely to be considered fair use. If I'm teaching a class, nonprofit educational, and I could probably put a passage from a textbook up onto the slides for my students to see, that likely would be considered fair use. But my general advice would be you don't want to necessarily rely on fair use if you don't have to. Generally, my advice would be if you think that there might be a copyright active on something, that you seek permission, before using it, especially if it's not clearly one of those situations where it's educational or commentary and criticism. You should also avoid using someone's work if you don't know if there's a copyright on it or not. We see this all the time, well, not all the time, but on a fairly regular basis, where a business might be put up a new website and they liked an image they found online, and so they copied and pasted it onto their website, and all of a sudden they're hit with a cease and desist letter. Generally from companies like Getty Images is a large one, large photograph repository, and they own copyrights on millions of photographs. And that's a scary thing to be on the end of a cease and desist letter, and it's something that could be avoided if you just are cognizant of other people's copyrights. And if you don't know if it has a copyright on it or not, just because it's something where you can copy and paste it off the internet doesn't necessarily mean it's free to do it. It may be considered stealing. It may be considered an infringement. So my advice is, if you like something but you don't know where it came from or if there's a copyright on it, you can use it as inspiration. Make your own creative works. Have something else commissioned. If you like that photograph of that flower, instead of copying it, go photograph your own flower. Become your own artist. In which case, then you don't have to be concerned about whether it's going to be fair use or whether there's going to be someone that could claim a copyright interest in it at some later point. All right. So some final IP thoughts here. I would say first, and this is just general IP guidance. Intellectual property protection, it's a process. It's not something where you ever just file an application and you walk away. It almost always an application is going to have to be shepherded through that process to its final registration or issuance. With copyright, it's probably less shepherding required than a patent or a trademark, but know that there generally is going to have to be something that happens. I say here, typically you must fight for the right. Maybe not so much with copyright, but you may have, the copyright examiner may have questions, and they will contact you, and you have to provide information if needed before they will make the registration. I also mentioned here on the last page, the final IP thoughts. Remember that IP is a business tool. It's a powerful business tool, but ultimately, at the end of the day, just a business tool. There's no legal requirements whatsoever that you go out and you register your copyrights or your trademarks or your patents. The value to having a good copyright registration is it gives you a basis to prevent others from copying your creative works and writing on your coattails, right? Especially if it's something that's valuable to you and your company. Having that copyright registration gives you all the right in the world to send these cease and desist letters, right? And sort of bark at people if they start knocking off your creative works without your permission. With respect to trademarks and patents and trade secrets, there are other reasons here, behind them being a powerful business tool, which we really didn't get into in this webinar. But like I said, I'd be happy to chat with others later about it. Also, IP, and this includes copyrights. You can use it as a shield or as a sword. There's more than one way to monetize your IP, including copyrights. So not only does it give you the ability to ward off your competition and to threaten people with infringement and lawsuits if they do begin copying you, but once you have your registration and that's effective, it is like a form of property. You have fenced it off and you can lease that property. We call it licensing in the intellectual property context. And so there's more than one way of monetizing and making money off of your creative works. So with that said, just sort of wrap up the webinar and then we'll open it up for questions here. I just want to leave you with the final thought. Hopefully now you remember the rule of thumb. What does a copyright cover? Well, it protects the works of authors. If we were testing, like I said, I would also accept copyright protects the expression of the idea, not the idea itself. And then remember, if you're going back to your respective businesses and projects, keep an eye out for these creative works. Is there something that has at least a little bit of creativity associated with it? Your websites, your manuals, your displays. And then you can make the educated decision now, do you want to do anything to secure that copyright registration or not? So with that being said, I will open it up to questions.
Okay, well, I will. This is Steve Schillig, and I remain amazed and grateful, Jake, that you can boil down such a difficult subject and make it understandable. So I certainly appreciate that. And if I learned anything in your series of workshops, the biggest takeaway is that we should be reaching out to a professional like you when we do run issues like this. So I'm grateful to have you not only in this call, but available for our clients when available and others. So are there questions? Bill looks like he has his hand up, so I'll go ahead, Bill.
Yeah, my name is Bill Davis, and my question is this. I have a profession, and we have a website. We also have Facebook presence, although it hasn't been very active for many years. So we haven't kept up on making adjustments and additions to the website or to the Facebook. But my question is this. I belong to a number of associations in different states where I'm also licensed. And as a part of that association participation, I get news feeds that are relative to the sort of work that I do. And some of it's pretty interesting as it relates to society and the law and, reports on cases, things filed, judgments, etc. So these 3 or 4 associations that I'm still active with distribute these basically through, in addition to their own blogs, also emails to me, like a couple of times a week. And I review them and see what might be interesting. So my question is this, what is the prohibition, if any, about forwarding those emails to other persons who may be my clients or other persons who just may be interested, although, to participate in emails or Facebook publication usually has some sort of business reason behind it. So obviously, if people find your information interesting and informative, they may be more inclined to talk with you and engage your services.
Yeah.
So what? And these different associations, they acquire the information from a regular news, the AP, the Post, whatever. It's usually a snippet with a description, and you can click on something and it may open it up and let you read the rest of it. I'm sure some of it lets you open it up once or twice, and then it says if you really want to get the stuff from the Post, you need to have a subscription. So how does all of that relate? And is there a hazard to trying to forward those emails or to publish the emails that you get in such a way that the people in the community get them and it would be hopefully interesting to those persons?
I appreciate the questions, Bill, and let's sort of unbundle all of that, because there's actually multiple issues that I think are sort of swirling around in the questions that you've presented. One thing I think I would say initially, is if a organization is forwarding, some sort of article to its members, and you want to then forward that on to your customers or your clients, technically, it may be considered a copyright infringement to be distributing a work without the permission of the original author. But it might be one of those situations, too, where either the organization is happy to sort of let you operate in the breach, so to speak, because it does just drive traffic back to them eventually. And another thing I would say, there may be even buried within your membership with the agreement that you have at being a member of an organization that permits you to do those sorts of activities. So even if it is maybe at a 10,000 foot level view, a distribution of work without permission of the author, there may be actually some agreement underneath your membership with that organization that allows you to do that. There's a couple other things here that are floating through too, because I think you mentioned about links, and someone can then, click back through to the original content. Generally, the distribution of web links like that is not going to be considered a copyright infringement. There's news aggregation websites that like to do that. One of the most famous ones, here is like Drudge Report. It's a news aggregator, and it just puts in links back to the original content, and that's generally going to be deemed acceptable from a copyright infringement. They're not reproducing the work, they're just providing a link so that someone can go to the original work and read it, and so generally that will be acceptable. The situation, one situation you might want to be aware of, and I'm sure you're not doing this, but let's say you receive an article, from this organization you're a member of, or you just see it on the internet, and you say, you know what, that was really well written, and you copy it and you paste it into your own newsletter, and then you start distributing your own newsletter with, that might be problematic. That might be considered a copyright infringement. Now, whether or not the author ever finds out about it or ever tries to assert their rights, that's another question. But it would be something I would not encourage. Also, be aware that simply providing attribution does not resolve one of any copyright infringement issues. I've actually had this come up before with a client, and they said, well, yeah, basically I closely paraphrased this content, and I provide an attribution. It says right here in my bibliography section, this is where I got it from. Well, if you didn't have permission to copy it, giving attribution is not enough. And so be aware of that as well. One thing that's perfectly fine to do, and sort of keep this in mind if you do have your own newsletters that you want to distribute to your clients or customers, is remember what I said about facts. Facts are not copyrightable. So what you can do is, if you like a particular article, you can read it, internalize it, understand the facts involved, and then write your own article based on those facts. I mean, you can use other articles for inspiration, but as long as it's not a close paraphrase or a copy of that, but your own expression of those ideas and those facts, then that's acceptable. It's sometimes a close call, right? But you might imagine, but that internalizing of the factual information and then creation of your expression of it, your expression, as opposed to somebody else's, that's perfectly fine. And in fact, you own the copyright, in that expression yourself at that point. So, like I said, there's lots of issues sort of swirling in your question, Bill. Did I answer all those okay, or do you have was there any other points there that I may have missed? Looks like Bill is still on mute. Steve.
He may have stepped away.
Oh, there he is.
How's that?
Yeah.
And so just as I asked the question about forwarding those emails in the form that they come, that has the different links to the news services. So is the forwarding of the emails themselves just in that format? If that was, if I had, 10,000 email addresses of people that I've come into contact with, and I wanted to share that email and so forward it, would that be an infringement?
Well, the good lawyer answer is it depends, and it really does come down to the facts. If you're the member of an organization, so you're a paid member, and they distribute information within their membership by email, and then you take that email and you send it outside of the organization to 10,000 others, right? Your own customers. That organization may raise that as an issue, especially if there's creative content in there. Like if they actually created this article. Now, maybe, like I said, they do expect that their members will be sharing, in which case that's fine. It's probably within the membership agreement. But it is a distribution of a work without technically the permission of the author otherwise. Now, if what you're distributing is an email that really doesn't have any creative content necessarily, but it's more just a list of links saying here's some useful links relating to this important topic, that likely would not be considered a copyright infringement in that case, because like I said, you are simply providing the web links to people so they can go and access the original content. You're not making a copy of it, right? You're not distributing it, though, your own version of it without permission. You're not copying and pasting any of those articles into your own newsletter and trying to pass it off as your own. So simply providing the links is likely not going to be an issue. I don't think, just to be fair and be perfectly clear here, I generally am not too concerned about that situation that you're asking about forwarding this organization's newsletter email to others. I doubt that actually would be an issue, but if it's something you're concerned with, you could always contact that organization and just confirm that, hey, just want to make sure I'm respectful of everyone's copyrights, and if I do share this with my own customers, is this, I just want to make sure that this is not going to be an issue. So that's one way of handling it, Bill, if you are potentially concerned about distributing others' content.
Okay, that looks like the end of the questions. I don't see anything else in the chat room. Jake, again, I want to thank you for your time today and for the information provided in the series. I think you agreed maybe that you'd consider offering this again sometime next calendar year, which we will get you on the schedule to do that. And your contact information is there for those that are on the call today. I know that he has helped a number of our clients on inquiries and questions. So I thank you for that, and I thank you for your time today. Thank those for attending, and I'll say goodbye and have a great rest of the afternoon.
Thank you all.
You bet.